49, CA Sanmati. Tanmay Rajkumar.
May I please, Your Lordship?
Yes.
Lord, before I go on to that decision of the Honorable Supreme Court, which I was reading just before the break, one point I would like to clarify, my Lord, is that when I made that statement that in the judgment relied on by my learned friend Lok Sikshana Trust, Justice Beg's decision was not a dissenting decision, but it was a minority view. He gave different reasons, but concurring with the final outcome. But it is Justice Beg's views which have been.
But he relied, Mr. Suryanarayan, he relied, Council for Revenue relied it only on the proposition that the activity of imparting education should be systematic.
Yes.
And the activity which you seek to undertake through trust deed does not amount to systematic activity. That for only that limited purpose.
So two submissions we have there to make, my Lord. In my case, my activities have not even started. So for the revenue to presume that I'm not doing a systematic educational activity is too premature. That is one. And the second thing is, in that case, if Your Lordships kindly see, there whether the trust was actually doing education or not was a factual dispute, and the Honorable Supreme Court finally said it was not an educational activity. Therefore, I would like to distinguish that judgment on that point. And so far as my submission that ultimately the views expressed by Justice Beg in the decision relied upon by my learned friend, that the profit-making activity of a trust does not make it a non-charitable activity has been approved by the Honorable Supreme Court, a constitution bench in Surat Arts. Therefore, even assuming, first of all, my submission was when I'm doing education, whether I'm also doing trade, commerce, or business is of no relevance. And second thing is, even assuming my activity is not education or any other general activity, if the other activity, trade, commerce, or business, is incidental to my main activity, there also I should be given the benefit of registration under section 12AA. So for that, those two propositions, my Lord, I'm relying on the Constitution Bench judgment of the Honorable Supreme Court.
Yes.
And on the second proposition, my Lord, that at the time of granting registration, the commissioner should not go into the genuineness of the trust, especially in a case where the trust was just formed and no activities have been carried on. I was relying on the decision of the Honorable Supreme Court in Ananda Social Education Trust, which is what I was reading just before the lunch break, my Lord. If my Lords kindly come to para 46, I'll just complete reading that judgment and then I'll go to the last proposition. Page 46, internal page 46, running page 46.
Para? You read para 7 and 8.
8, 9 also, my friend read. I will read from 10, my Lord. It was argued before us. My Lords have it?
Yes, yes.
It was argued before us that the commissioner is required to be satisfied about two things. Firstly, that the objects of the trust, and secondly, its activities are genuine. If there have been no activities undertaken by the trust, then the commissioner cannot assess whether such activities are genuine, and therefore the commissioner is bound to refuse the registration of such a trust. We have given our anxious consideration to the above submissions made by so-and-so, appearing for the appellant, Director of Income Tax, and find that it is not possible to agree with the same. The purpose of section 12AA of the Act is to enable registration only of such trust or institution whose objects and activities are genuine. In other words, the commissioner is bound to satisfy himself that the object of the trust are genuine and that its activities are in furtherance of the objects of the trust, that is equally genuine. Since section 12AA pertains to registration of the trust and not to assess of what a trust has actually done, we are of the view that the term activities in the provision includes proposed activities, that is to say, a commissioner is bound to consider whether the objects of the trust are genuinely charitable in nature and whether the activities which the trust propose to carry on are genuine in the sense that they are in line with the objects of the trust. In contrast, the position would be different, where the commissioner proposes to cancel the registration of a trust under subsection 3 of section 12AA of the Act. There, the commissioner would be bound to record the finding that an activity or activities actually carried on by the trustee are not genuine, being not in accordance with the objects of the trust. Similarly, the situation would be different where the trust has, before applying for registration, found to have undertaken activities contrary to the objects of the trust. So, my lord, while granting, there are two different scenarios. While granting register, if it is a case of fresh registration, all that the commissioner can look into is the objects that have been specified in the trust deed, because no other activities have started. But in a different scenario, say for cancellation of registration, the commissioner can actually look at whether I am doing commercial activity or a charitable activity. For him to presume that I am doing a commercial activity or that the trust is for a commercial intention, at the time of registration of the trust, my lord, is premature. And therefore, that cannot be the reason to deny me the registration. And that is what the Honorable Tribunal has held. Apart from saying that in any case that the objects referred to by him are only incidental to the main object of education. But for the last proposition, that which the tribunal also has said, that in any event that these are all things that can be taken care of at the time of assessment. My lord, I'm relying on 3 judgments of this honorable court. The latest, my lord, is DR Ranka Charitable Trust, which is at page 49, which relies on the earlier 2 decisions of this honorable court. So I'll just read one paragraph of this judgment at page 50, my lord, para 4. My lords have para 4. In support of his case, he relies on the judgment of this court in Garden City Education and the Venkatesha Education Society, wherein it was held that the 2 relevant considerations are that the authority should firstly satisfy itself that the objects of the trust should be in the nature of charitable purposes, and secondly, whether the activities of the trust are genuine. So far as the object of the trust is concerned, so long as it fits into any one of the objects as enumerated under section 215 of the Act, such a requirement stands fulfilled. So far as the second requirement with regard to genuineness of the activities is concerned, the same could be arrived at only during the assessment proceedings. Under these circumstances, we are of the view that the tribunal was justified in coming to the conclusion that so far as the factum of SSE being involved in any charitable activities or not, whether the income so derived has to be apportioned towards any other purpose or not, could be considered only during the assessment proceedings. Considering of the application is quite different from the assessment of income of the SSE. Therefore, at this stage, it is suffice to hold that the conditions for grant of exemption have been satisfied by the SC. The tribunal was justified on facts and in law to pass the impugned order, so and so. One of the other 2 decisions which this honorable court relied on also have filed. I will not read, my lord, the paras 16 and 17 of Garden City Education Trust. Page 56, my lord. Para 16 and 17, I'll not read, my lord, because that the proposition has been. And in the other judgment, Venkatesha Education Society, it is paras 13 and 14. At page 65 to 68, my lord.
That's all.
67 to 60. Yes, my lord.
Your Lordship, one submission, my lord. Your Lordship, my respective submission is that the tribunal has not gone into entire objects, my lord. It has only specifically chosen 1 or 2, my lord.
You have told us.
Yes, my lord. Your Lordship, I rely upon the judgment of this honorable court in case of Ananda Social and Recreational Trust, my lord. The honorable apex court has clearly held that the commissioner has to ensure the wording has been used, my lord. Ensure that objects have been met with.
That's it.
That's it. That's all.
Thank you.
Grateful.
plus 51, CA Sanmati, CV Chandrasekhar.
For the respondent, my lords.
Your Lordship, in this case, the assessing authority has allowed the claim of the assessee, my lord. The assessee is a government of India undertaking. The assessee has made payment of rupees 10 crores for road development, my lord, in surrounding its factory premises. For development of the road that has been denied, that has been allowed by the assessing authority in the original assessment order, and subsequently the commissioner has taken up proceedings under section 263 for revision, holding that that is not correct, along with two other items. Against that commissioner's order, the assessee preferred appeal before the tribunal. The tribunal has held that as far as this first issue is concerned, the assessee is entitled for the relief. My lord, it is allowable expenditure. And another two issues are concerned. The tribunal holds that it comes under 263. Commissioner was right in invoking the addition, in invoking the 263 proceeding. Subsequently, my lord, the assessing authority has passed the order, my lord, relating as per the directions of the commissioners, and assessee preferred appeal before the first appellate authority. That matter is pending. Now, the subject matter before the tribunal was whether the 263 order was correct or not. That is the only subject matter before the tribunal. But the tribunal, without going into whether the 263 twin conditions are satisfied or not, the tribunal holds on merits that it is an allowable expenditure. Against that order before this honorable court, my lord, your lordship may kindly have the paper book filed by me, my lord.
Mr. Sanmati, we will hear you tomorrow.
Your lordship, it is actually it is covered, my lord. Your lordship may dispose of, my lord.
You should tell.
Your lordship,
What-
because only these factual changes I wanted to make submission, my lord. Your lordship,
Covered by this case here.
your lordship, covered by the honorable apex court judgment, my lord, in the case of Sri Venkateswara Satnarayana Rice Mill Contractors.
Very good.
Your lordship may kindly extract the last portion, para 10 of that judgment, my lord.
He's saying something else. Which judgment?
Your lordship, Venkateswara Satnarayana Rice Mill, my lord, Rice Contractors Company. This small compilation given by me, my lord. Your lordship, may I quote the citation, my lord?
Sugar mill.
Yes, my lord.
Thereafter.
Your lordship, serial number.
Yes, got it.
Your lordship can come to page number 19, last page, my lord.
19.
19, my lord. Your lordship can quote para 10, my lord.
Okay.
By following this decision, my lord, your lordship has also held against revenue in ITA, in one of the judgment, my lord, in ITA number
Your number?
460 of 2017, my lord, dated 17/3/21. 460 of 2017 and connected matters, my lord.
Thank you. Thank you, Mr. San.
These decisions are placed by me in my paper book compilation, my lords.
All right. Thank you. Thank you, Mr.
Much obliged. Covered in favor of the assessee, my lords.
Yes.
Much obliged, my lords.
That's why we are not hearing you.
Much obliged, my lords.
Yes.
Number 52, Sri Jivanjani Ralgi.
I appear for the respondent, my lord. Good afternoon, my lord.
Good afternoon, Mr. Shankar. Yes. What is it? Writ appeal?
Writ appeal, my lord.
Which for the appellant? Appellant is not there.
Any day convenient, your lordship.
Tomorrow or on Monday?
Whatever date convenient to him, because the point is very simple, my lord. I have placed today one small paper compilation, only one page, and then in which they have now put a show cause notice to call book or something. So they don't want to pass an order. My 2 crores stuck with them from 10 years. Whenever, maybe take it on Monday, my lord, so that Jeevan will also get prepared. Monday.
Monday. None for the appellant, Mr. A. Shankar, learned senior counsel, with Mr. V. Chandrasekhar, awaiting appearance of learned counsel for the appellant.
My lord, it is not Chandrasekhar, my lord. Sandeep Uyilgol, my lord.
Acha, Sandeep
Brief matter.
Pulligol. Sandeep Pulligol.
Sorry, my lord.
List on 31st January.
Hardship.
Right.
Number 53, Sri S.V. Prakash, Government Advocate, Sri N.K. Ramesh, Sri N.K.T.,
Yes,
Sri
madam.
Ravi Verma,
Appear for petitioner, madam.
Yes, madam.
Kindly have it next week, my lordship. There is senior,
Yes, we thought that you are ready to argue.
senior is not keeping well.
Mark the presence, learned counsel for the appellant, praise for short adjournment, list in the next week.
Number 54, Srimati Maya Honda,
I appear for the petitioner, my lord.
Yes.
The case has become infructuous. I filed a memo for withdrawal today morning.
Learned counsel for the
Case may be dismissed as not pressed.
admits that he has filed a memo seeking leave of the court to withdraw the writ petition on the ground that same has been rendered infructuous. Full stop. The memo is taken on record. Accordingly, the writ petition is dismissed as infructuous. Right. 55.
55,
I appear for the petitioner.
Mr. Patil.
Kumar, Government Advocate,
I appear for response 5 and 5, my lord.
Right.
Sri Gowda,
Ready?
I am ready, my lord. But I
Other
have,
respondents are not there.
please, my lord. But again, the
Let it
contesting
come
respondent is
tomorrow.
the, please, my
Tomorrow.
lord. Tomorrow.
Please tomorrow. 55.
I request for some other day. Tomorrow I've got a lot of cases. My lord.
Oh, 1st February.
Much of that.
Obliged.
1st February.
Possible.
This on 1st February. Awaiting appearance of learned counsel for respondents. List on 1st February 2022. He will appear for correspondent number 5.
May I make one submission, my lord?
Yes.
In this case, I have filed an application for impleading. The proposed respondent is served and represented. If they
We'll
have
see
no
on-
objection, very well, my lord. Obliged. We'll see it on.
Yes.
number 56, Sri R. Shashidhara, Government Advocate,
Yes.
Sri R. Shashidhara.
My lord, I appear for the petitioner, my lord. My lord, I
Ah.
have certain. I appear for the petitioners, my lord.
Ah.
My lords may kindly take up it next week, my lord. There are certain judgments which I want to produce before this honorable court, my lord.
Judgment.
I'll file my list of citations. My lords may kindly have it next week, my lord.
Praise for adjournment. List in the next week.
For posting, number 57, Srimati
Grateful,
Nayanthara.
My lords, I'm appearing for the petitioner in this matter. I'm led by learned senior Mr. Tata, my lords.
Yes, madam. So it has to. Yes, Mr. Datta. Okay.
This
He's appearing for respondents. In fact, it's today the matter has come up for a date to be fixed for hearing, right?
Yes, my lord. What I wanted to mention was this won't take much of your lordship's time because the only question is whether a student's hostel is a residential accommodation or not, and that is directly covered by a division of the Bombay High Court. Of course, not binding on my lord, but certainly some persuasive value is there. And yes,
This is Nirali.
and
Gone through the judgment.
it's for the typeset.
Oh, when would you argue? Yes, Mr. Datta, any date next week?
Yes, my lord. Only thing lordship will take it because what's happening is now they're trying to take all hostels in India as
all right. It will be. You tell us the date of your convenience. It will
no,
be
your
taken up
convenience, your lordship's convenience, not
no.
your lordship's convenience.
Mr. Nirali, please. Which date?
Can it be next Friday? Possible?
Friday. Friday we have some this thing. Benches, different combinations. So
All right.
effectively at times we work with. Let it be a Thursday.
Thursday, all right. I'll take my chance.
Thursday. Mr. Nirali. Which date?
Third.
3rd of February, Mr. Datta.
Yes,
Okay.
yes. My lord, I'll also be ready. If your lordship will take it post lunch, I'll keep myself free. We'll finish it, my lord, because
Yes. Yes, Mr. Arvind Datar, Lalit
My
Senior
lord, the
Counsel.
interim order may kindly be extended.
Yes, Ms. Nayantara BG, Learned Counsel for the Mr. Jeevan J. Neralji, Learned Counsel for Respondent number 2. Let the rate petition be listed. A memo for posting is allowed. Let the rate petition be listed for hearing on 3rd of February 2022. Right? Interim order granted on regular occasion shall continue.
Pray for me.
T.N. Manmohan,
Please, Lord, the petitioner, Lord, belongs to Lord, a Christian minority.
Who represents this Karnataka Examination Authority?
Lord, Mr. N.K. Ramesh, Lord, I tried reaching him, Lord, but in vain.
So you supply him a copy. We'll take it up tomorrow.
Only one request, Lord. But can it be taken up in the morning, the top of the list, Lord? The only reason. Grateful.
Please mention it will come up tomorrow. You mention.
But I will serve the government insofar as the first respondent state of Karnataka.
T.N. Manmohan, Learned Counsel for the petitioner, undertakes to supply a copy of the writ petition to Mr. Learned what? Additional government advocate, as well as Mr. N.K. Ramesh, who represents respondent number 2. Office is directed to reflect their names in the call list on tomorrow is what date? 28th January 2022. Madam, you write this and you will have to sign this. Write it by hand just now, so that we sign it before.
Grateful.
You have the freedom from mask being your chamber. Yes.
I am just recovering, Lord. So,
oh, you are recovering. Oh.
Yes, Lord. I think it has hit everybody this time. Nobody was spared.
Yes. But for good, I mean, good riddance, right? In a way.
Yes, Lord. We're hoping that this comes to an end, Lord, once and for all. This harassment of mask also is done away with.
Yes.